Okay, we'll wait a second to let people join in. You folks hear me at home?
Yes.
Yep.
Professor, may
Okay.
I ask a question, please, about the exams? Are they going to be in person or are they going
Oh boy,
to
that's
be
an old song.
online?
That's what a lot of people in Vietnam.
Professor, can you hear me? This is Linda.
Hello, everyone.
Hello.
Let's talk for a minute before we get in. We have a lot of material to cover here today. Everyone at home, one more time, can you give me a thumbs up or nod if you can hear me? Okay, good. And remember, it's best to keep your microphone muted. If you want to speak, please unmute yourself and speak, and then remute yourself. I don't know what that means after you're done. Okay. I wanted to talk just briefly about the. We'll keep playing with the heat here. I wanted to talk briefly about the the two exams that we have left. I will put something out in writing on this. I've already started to write what I guess the administration is calling the major exam, the one that is given before Thanksgiving. That one is going to be given on Tuesday. I believe it's the 22nd of November. What I'm planning for that exam, there will be no multiple choice questions on it. The only multiple choice questions that you will be getting are on the quizzes. I know that's the subject of a lot of consternation for a lot of people, so hopefully that will make you happy. I'm looking at the exam as being an hour and a half, and there's going to be two exams, the major exam and the final exam. So the major exam will be on the 22nd, probably going to be an hour and a half exam. And it's going to be some short answer questions that only require a few words in the answers. And then two short essays. That will be the entire exam. The essays will be half-an-hour essays. And I plan on doing the exact same thing with the final exam that will be given on during the exam period. And ours is late, I want to say. Actually, I think I got the November 22nd date wrong. I think it's November 24th. It's Tuesday, November 24th is the major exam. I think the final exam is given late. I think it's on, I want to say December 22nd. Does that sound right? So, you know, and that will be a similar exam. There'll be no multiple choice questions. There'll be a short answer section, and I'm planning on two essays, two short half-an-hour essays. Those are the types of essays that are given on the bar exam, okay? Neither of those two exams will be comprehensive. And when I mean comprehensive is neither will cover the entire course. The first exam given right before Thanksgiving, the so-called major exam, will cover everything that we've done up until class 16. That's the last class of the structure and form of the government before we started individual rights. Again, I'm going to put this all in writing for you so you have something to rely on, okay? And then the final that is given in December, near the holiday, at the end of exam week, well, exam 2 weeks, will be from class 17 until the end of the semester, okay? So you won't have to know, for example, Marbury, you won't have to write about, I hope you'll know it because you will have learned it for the first exam. You won't have to tell me about Marbury versus Madison in the December exam, but you might have to tell me about Marbury versus Madison in the November exam. You get the point? So each one will only cover that section. And I think that's the fairest thing to do, considering that we never planned to have sort of two finals in the class. The first final is coming. You guys will have, like a couple of days of reading week, and that's about it. Because my understanding is that our last class live will be on November 17th, Tuesday the 17th. Then I think your first exam is going to be Friday, which is evidence. And then my exam is going to be the following Tuesday. So we don't have the full reading week that you had previously. Teddy, turn on your, unmute yourself.
So my question is, for the two exams, is the point value between them cut in half?
So yes, and everyone's freaking out about the quizzes. Let me remind you that we grade on a curve, and that you all suck on the quizzes. So you're not alone, okay? And I expected you to. You guys are novices at this. What I'm seeing is a lot of 2s and 3s on the quizzes, to be honest.
Yes.
Yeah, there's a lot of 2s and 3s. And the last one seemed particularly low for a lot of people as well. So,
Professor,
this is a process. Learning how to do these quizzes is a process. And I think it's one that's important to start you off on early in your law school careers, rather than, I never saw a multiple choice question until I graduated from law school and I got into my commercial bar review courses, and I had 12 weeks to go to learn how to do them. That's not a very good way to prepare for the bar exam, to do it all in 12 weeks.
Professor, do you see the
in any event,
questions
that's
on
why I do
the,
the quizzes. So that's 30%, which leaves us 70% of the class, or 70% of the grade. And we'll just divide those two final exams 35 and 35% each. Okay.
Professor,
So the exams will still count for 70%. It's just that neither will be comprehensive. What I had planned on, obviously, was just one big exam at the end of the semester plus the quizzes. We obviously can't do that one big comprehensive exam. So it'll be, each one will be self-contained, classes 1 through 16, and then 17 through the end of the semester. Okay.
Professor.
So that's what I'm thinking. And as I say, I'm going to put that in an email to you all, so you all have that. I'll probably post something on the Twin site as well.
Professor.
Give you reassurance that I won't change my mind.
Professor.
You
Professor.
guys have dealt with a lot of changes and plans as it is. That's what the whole history of the pandemic is so far, isn't it? You
Yes.
don't know what to expect the next day, for heaven's sake.
Professor.
It's something we're all kind of burdened with.
Professor, I
Right.
believe
Professor,
Jade is trying to get in touch with you.
Let's jump. Oh, is
Professor.
someone saying something?
Yes, we have two questions. I don't know if your mic is on,
No? Okay.
but anyway,
So,
Professor.
Professor,
Professor,
Professor.
Can unmute yourself.
we are
You
unmuted.
are muted.
I think he
I'm
has,
gonna look in the chat to see if someone chatted me.
Yeah, we can't hear, you can't hear us.
He cannot hear you. Oh, yeah, Linda, I cannot hear you. I couldn't hear you before. Try to unmute yourself and speak again.
Professor,
Can
can
everyone at
you,
home unmute themselves and speak to see if I can hear them?
Well, I've been trying to speak.
we're trying to speak to you.
I'm
We are
not hearing
trying
anyone at
to.
home.
hello?
We
Hello?
have,
We're all speaking, Professor.
We are
we
all
have,
speaking
I don't
to
think I've
you.
muted the class.
Can you hear us?
Hello?
Hello?
Hello, Professor?
Yes, I can hear you now.
Oh, okay.
We've all been trying to ask you questions. At the beginning of the chat, there are questions. So is there going to be an option on weekends if we can't get those days off on the holiday weeks? And is this exam in person at school or online?
So there's an exam schedule. And Teddy, turn yours down again for me. That's okay. There's an exam schedule, and I'm required to give the exam on the day that it is scheduled. And I realized that it is not on the same day as class. Normally, well, no, it is on the same day as class, so you would be taking it anyway. So on Tuesday, the 24th, you will have the option of taking it at either 4 or 6 o'clock. Usually the day students take it at 4, the evening students take it at 6. I'm not gonna care which one you take. Well, I'm gonna have to care which one you can take, because I can't have more than 24 students in the classroom. Now, my understanding is that if you are a 3, and I don't even know what this stuff means, to be honest. You've all been categorized into 1, 2, 3, or 4. If you are a 3, you have a medical excuse not to show up in person and to take the exam. My understanding is that the administration expects everybody else to take the exam. So I don't know about people who are 4s. I think I call the 4s the conscientious objectors, people who didn't sign the community agreement. I don't think the administration is going to have you come into the building and take the exam either. So if you're a 1 or a 2, and I don't even know the difference between 1s and 2s, to be honest, and you can bring that up with the administration or the registrar. If you're a 1 or a 2, you're expected to take it live. The way the numbers are going here, guys, I don't know that anyone's going to be taking this exam live. You know, we're still talking more than 3 weeks out. And I believe that it's going to be pretty grim as far as the numbers go by that point. So I don't know what the administration is going to do. And once again, it's just another question of, you know, the pandemic being so unpredictable. Okay. Now, so did I answer both of your questions, Linda?
Yes, Professor. I was actually reading from the chat, so I was trying to echo everybody's questions.
Oh, I see. Okay. Okay, good. So does that answer everyone's questions?
I have one more question, if you don't mind. This is Carol. I was
Yes,
wondering,
my other question would be, Professor, is that the new examsware software that we got the email for, I don't know if we're going to be using that for this final or.
I'm told we are going to be using that from now, not on my quizzes, but we're going to be using the new exam software for everything from now on.
Okay.
And what that does is, I guess it provides security. It has an artificial intelligence component. You have to sit in front of a camera when you take the exam, and it can detect whether you're looking at other documents and things like that. So that's why it's the exam, it's the software that they used on the bar exam. And I got to tell you, the security on the bar exam is through the roof. It's crazy. All right, let's you know, as I say, as I learn more information, I'll share it with you as far as the actual administration of the exam, whether it's live or whether it's not. But I'm pretty solid about the way the structure of my 2 exams and how they're going to be graded and the like. So let's move on. We had started by talking about the distinction between content-based and content-neutral laws. Content-based laws are either restrictions that are either restricting subject matter or viewpoint. I gave you the analogy of a town that says no speaking in favor of abortion rights on any public property. That is a viewpoint restriction, so it makes that law content-based. But even if the town had said no talking about abortion at all on public property, whichever side you're on, that would still be content-based because it is a subject matter restriction. It is aimed at the content of the speech. Content neutral laws are so-called time, place, and manner restrictions. They are laws that place restrictions on when you may speak, where you may speak, and sometimes how you may speak. Can you use a megaphone, for example? Those are not subject to strict scrutiny like content-based restrictions. They are subject to intermediate scrutiny instead. So today I'm going to start you out by confusing you even more, because you're going to see that, you know, this sort of content-based, content-neutral dichotomy creates results that the court doesn't necessarily like. So it's going to use a couple of tricks here to suggest that something that is clearly content-based is really content-neutral. Okay, and so I apologize in advance for the kind of muddling things up that's going to be coming here. So I put this quote in here right out of the Chemerinsky book, suggesting the first issue that we're going to deal with. If it is clearly a content-based law, can you somehow justify it by saying, well, the intent, though, was not to restrict speech. The goal was not aimed at speech. So here, Chemerinsky says important problems arise in applying the distinction between content-based and content-neutral laws. First, does a permissible purpose for a law prevent it from being deemed content-based, even if the content restriction is on the face of the law? In the Turner case, which used to be a big case in the case book, it's not anymore, the court said, nor will the mere assertion of a content-neutral purpose be enough to save a law which on its face discriminates based on content. As you'll see, the court's lying when it says that, because the very next case that we're going to look at suggests just the opposite. Okay, facial content-based restrictions will be deemed content neutral if motivated by a permissible content neutral purpose. And so we come to the City of Renton versus Playtime Theaters. This might be our first pornography case. There's plenty of these in First Amendment law, so get used to them. Here, the City of Renton. Well, look, I'm going to tell you sort of a fact of life right now. Most speech that's based on sexual content is protected speech. There are two forms of speech based on sexual content that are not protected speech. The first is obscenity, and the second is child pornography. The result of this is that ordinary pornography is protected speech. And so with ordinary pornography, what one must worry about is if there's a restriction on pornography where you can put it, then it's a content-based restriction, because obviously you're making the restriction on the fact that the content of the speech relates to sex, okay? And this creates a huge, huge problem. It essentially means that when towns do zoning work, and here's the way that zoning works, is towns segregate the geographical area of the town into different zones. One zone might be a residential zone, one might be an industrial zone, one might be a retail establishment zone. You can get even more specific. You can have single-family residents, multifamily residents, and the like. The idea of zoning is that separating property into different uses and keeping the uses apart is a good thing. So then what do you do with adult bookstores, adult theaters, things like that show, sexually explicit films, or have sexually explicit books that don't rise to the level of obscenity and are not deemed child pornography, which we'll talk about later on. You can't prohibit, you can't zone for that. They can go anywhere, essentially. because the government would have to come up with a compelling governmental purpose for preventing that from happening, okay? So the court is not really happy with that sort of unintended consequence of this content-based, content-neutral distinction, and it addresses it in the Renton, Washington case. So the fact of life is that every single town has to allow adult entertainment establishments of some type, okay, in their zoning laws. There has to be a place for them, because to do otherwise would be to violate First Amendment rights, free speech rights. So what the cities and towns then tried to do is to put them in places where they would be least offensive, and quite frankly, even put them in places where they might not want to go, with the hope that they won't come to my town, okay? And that's what Renton seems to be doing here. It passes a zoning law. It prohibits adult motion picture theaters within 1,000 feet of any residential zone. So that's essentially a football field of within any residential zone, a little more than a football field. Church, park, or school. So think about your city or town and think of where all the churches, parks, schools are located, and then take around the perimeter of it, draw a line of 1,000 feet, and you're taking up big swaths of the town where these establishments cannot come. And so this really does severely limit where these establishments may operate within the city. So the Playtime theaters here, obviously an adult entertainment establishment, sues, and the court comes up with this formulation called the secondary effects formulation, okay? This is clearly a content-based restriction, right? I mean, on the face of the law, it says you can't be in these places if you are an adult motion picture theater. So it's certainly at least subject matter content-based. But the court says, no, this is content neutral. And the reason that it's content neutral is because the city of Renton doesn't really want to restrict the ability to engage in adult speech, in sexually related speech. No, what it's trying to prevent are the so-called secondary effects of these adult motion picture theaters. And although the court doesn't ask for any proof that these secondary effects flow from adult motion picture theaters, it says that, well, prevention of crime, protection of the city's retail trade, maintenance of property values, protecting quality of life of the neighborhoods and commercial districts, protecting the quality of urban life. These are all goals that are not related to the content of the speech. So even though you've got a law that appears to be clearly facially neutral, facially content-based, facially restrictive based on the content, the court here is saying, no, it's not what it appears to be. It's the motive behind the content that's important. And this, creates a lot of problems. The big problem that it creates is that a government can restrict just about any kind of speech and come in and say, we weren't intending to curtail the speech. We weren't trying to aim at the content of the speech. It was the secondary effects of the speech that we were trying to prevent, and then come up with some bogus secondary effects. Now, again, I'm not, suggesting, quite frankly, I wouldn't want an adult motion picture theater to be in my neighborhood. Because why not? Because I raise kids in my neighborhood. I mean, you know, no parent wants an adult motion picture theater to be nearby, and I had boys to boot. So on the other hand, they've all grown up, so maybe I would, well, no, I'm joking. So so you know, and it's funny when I was it's funny how our attitudes change as we age. When I was 18, I was sure happy that the drinking age was 18. When I had kids, I was sure happy that the drinking age was 21. So your perspective changes as your life changes. Chemerinsky puts a rub on this. It appears that there's a presumption to that, you know, if it's on its face, if it's based on viewpoint or the message, it's presumed to be content-based, but the government can essentially, you know, overcome the presumption, refute it by persuading a court that the regulation is justified by a content-neutral desire to avoid undesirable secondary effects. The content-neutral justification must be truly unrelated to the desire to suppress speech, and it must be unique to the speech suppressed as compared to the speech allowed. I'm not sure I totally agree with that last sentence, as the dissent pointed out, and I forget who the judge dissenting was. At this point, it might have been Stevens. As the dissent pointed out, he had no problem with the secondary effects rule, but he would need some kind of proof that these secondary effects actually do flow from adult motion pictures. And he didn't feel that the record justified that. And then you get into a sort of a battle of the experts, right? You know, some psychologists or sociologists saying, oh yeah, you know, or criminologists saying, adult motion picture theaters causes crime to come to the neighborhood. You know, I think we've shown that casinos cause crime to come to the neighborhood. I'm not sure that we've proven that crime comes to a neighborhood when there's an adult theater near there or not. But you know, if it does, then Stevens would buy that. But he would at least want proof. Now here's our second issue, and this one is almost unavoidable. Okay, sometimes a government necessarily must make decisions based on content. Okay, so I can point to an example of this real easily. You live in a town or a city that has one or more public libraries, right? Obviously, you know, the library in your town, the library in your city is not the Library of Congress, which has every freaking book in the world that's ever been published, right? So libraries have limited space, limited budgets, and libraries need to make choices into which books it's going to put on the shelf. Will you agree with me that the town that owns and runs the library is now necessarily making choices based on the content of the materials? So obviously, if the demographics of the town are such that there's a lot of elderly people, the library will probably have a lot of materials that, you know, are the elderly like to look at. And you know, you get into questions when there are controversial books that are published. You know, say Lolita was banned from, considered one of the great artistic works of all time, but it's about a creepy guy who has a love affair with a 14-year-old girl. And it was a scandalous book when it came out and was banned. So, you know, does the author of Nabokov, does the author of Lolita, you know, have the right to say you're suppressing free speech rights by not having my book in the library? So sometimes the government has to make decisions based on content. Well, what do you do in that case? Do you shut down all the libraries? Or, you know, do you say that if anyone wants to put their own book in the library, they're free to do so? This case is sort of an example of it outside of the realm of libraries. National Endowment for the Arts versus Finley. The guy on the right is a guy named Robert Mapplethorpe. Robert Mapplethorpe was one of the great photographers of the 1970s and 1980s. Truly very, very talented photographer. He was gay, and he ended up, instead of taking sort of still lifes and photos of flowers and portraits of people, before he realized that he was gay, he actually lived with Patti Smith. Have you guys heard of Patti Smith? The sort of punk rock singer from the 1970s and 1980s. That's when she was big. She was one of his favorite models for portraits, portrait photography, and very beautiful work. As his homosexuality developed, he started taking photos of men engaged in rather graphic sexual acts, and his photography became very controversial, and some of it, quite frankly, hard to look at, to be honest. That's the guy on the right, and the thing on the left is apparently a painting by a guy named Serrano, and this is called Piss Christ. Serrano was not a big fan of religion, and this is a picture. You can obviously make out that it is a painting of the crucifix with Christ on it. What you can't see from this photo, and I'm glad you can't, is that it is sitting in a jar of urine. And so, obviously, a fairly offensive, shocking depiction for the sake of art. Now, the National Endowment for the Arts is a governmental organization that gives out grants to artists to try to encourage, moving forward in the art world, trying to fund the most talented artists, in music, in graphic art, and the like. And they only have a certain amount of money that they can give out in grants every single year. And so they have to make decisions, just like your local library has to make decisions on which books to put on the shelf. The NEA has to make decisions as to who gets the money. And Congress, I think, had seen enough of Robert Mapplethorpe's work and Serrano's works, and had decided that they don't think that governmental money, taxpayers' money, should be going to fund these types of offensive artworks. So Congress passed a law saying that the NEA was required to take into consideration general standards of decency in respect for diverse beliefs and values of the American public when making these awards. Obviously, one might think, sort of aimed at the Mapplethorpes and the Serranos of the world, general standards of decency. Some controversial artists challenge the law. They say it's an infringement of their free speech rights. And the court holds that this is not a free speech violation, even though this is clearly a content-based decision. This is a situation where a content-neutral decision is impossible. How can we determine whether an artist is a great artist who deserves funding without looking at his artwork, right? Or her artwork, essentially. It's inconceivable that you can have a content neutral test as to who gets the money. So Justice Sandra Day O'Connor writes the decision and sort of comes up with sort of a new test here. When the government is required to make content-based choices in areas such as making grants, deciding what to publish in government publications, choosing books for a library and that type of thing, the government is allowed to make content-based choices as long as the government is viewpoint neutral in doing so, okay? So if it's denying Robert Mapplethorpe money because the government doesn't approve of his same-sex message, then that would be viewpoint-based rather than viewpoint neutral. So it has taken the content-based test, which can be satisfied with either viewpoint restrictions or subject matter restrictions, and it has essentially allowed subject matter restrictions, but not viewpoint restrictions, okay? And it is thus kicked these into the content neutral category, essentially. No, and the same question here is, you know, you're still going to have sort of masked viewpoint considerations that are being called something else. Now we have another situation, and this one's a little bit complex. It's complex because we're going to talk about some offshoots of this later on in a different situation. What happens if the government doesn't like the message? Is the government required to display a message it doesn't like on its own property? And this comes up in places like public parks, in courthouses, and also, believe it or not, it comes up on the question of license plates. We're going to talk about license plates several times. Later on, for example, we're going to talk about Woolley versus Maynard, which involves the New Hampshire license plate and its motto, live free or die, okay? So this case is Pleasant Grove versus Sumum. Sumum is an alternative religion. It's a rather strange alternative religion. My slides in my First Amendment course show some of the Sumum symbols. It seems to be sort of a religion that mixes Egyptian beliefs with Indian beliefs. And I don't mean Native American beliefs, I mean Indian beliefs. And it was started by this guy named Corky Noel. They believe in the practice of mummification. And at your death, you can become mummified and kept in one of their crypts, which looks like a pyramid essentially. And they also allow you to bring in your pets to mummify them if you are very close to your pets. And then you can sort of bring them home as mummies where they'll sit in your house for eternity, I guess. Corky Noel himself has been mummified and is sitting in the headquarters of the Sumum religion. Well, Pleasant Grove has this park, and in the park are monuments that had been donated over the years. And one of the monuments is the Ten Commandments. And the Ten Commandments is obviously a Judeo-Christian monument. It's related to religion. So Sumum comes in and says, hey, we want to put one of our pyramid type things up. And you've allowed the Jews and Christians to have their monument, the Ten Commandments. So you kind of have to let us put ours up in the park, and we'll donate it and we'll maintain it. And, you know, just so we're not offensive, we'll make it about the same size as the Ten Commandments monument that is already there. And Pleasant Grove, Utah said, no, thanks. We don't want to take that particular monument. Thanks for the offer, but we're not going to take you up on that one. Obviously, the case goes up to the Supreme Court. Pretty clearly content-based decision, isn't it? We don't mind the message of the Ten Commandments. They're acceptable to us, but the message of the Sumum religion is not all that acceptable to us. So, you know, sounds like a pretty much content-based restriction. The court says no. This is nothing more than essentially the government exercising its own First Amendment rights. When the government exercises free speech, it's not a violation of anyone else's free speech rights. Governments are allowed to convey their message of what they deem to be, what they stand for. This sentence sort of says it right here. Governments are allowed to display monuments on public land that reflect the values and ideas of the government. Now, we're going to learn later on that this is not always the case, by the way. For example, the Ten Commandments cannot be put into a courtroom, okay? But we're going to learn that the Ten Commandments can be put at the state capital of Texas, Austin, if it's not displayed too prominently, okay? So here the court is saying essentially, if it's the government who doesn't want its message to be eroded, then the government doesn't have to allow the free speech on the public land. And the court said, this would ensure that there are no conflicting messages, and it wouldn't confuse people as to what the government, what Pleasant Grove itself believed. Does it believe in the Ten Commandments, or does it believe in the Summum Monument? This is just a caveat. Even though the government has the right to free speech, the government cannot interfere with other people's rights to free speech. And we're going to see that there are places where people generally get to assemble and engage in free speech. Now, here's our first license plate case, a relatively recent case. Well, the facts are a relatively current case as well. Walker versus Texas Division Sons of Confederate Veterans. You guys drive around on the roads, I'm sure you do. And you see now that there are a whole bunch of specialty plates. In Massachusetts, I've seen Boston Red Sox plates. I've seen Patriots plates. I've seen Bruins plates. I've seen breast cancer plates, the pink ribbon plates. I've seen the colleges, Boston College, UMass, you name it. What a lot of states do is they say to these institutions, if you want your own dedicated plate that people will pay more for, we'll charge a higher rate to register the plate. We'll take a little bit of the money, the extra money that would come in, but we'll give you some of the money. And it's a good way to both, number one, raise some money, and number two, to get your message out there, do some free advertising driving around on the cars. In every state, the state has to approve the plate that's put on. So, for example, there was a case, I wish I remember how this result was resolved. I remember seeing this in the news. There was a case in New Hampshire where apparently a lawyer put on his plate, instead of having numbers, his plate said "Cops Lie," COPSLIE. And not a very smart lawyer. I mean, that's almost an invitation to get pulled over, isn't it? Every time you're out on the road.
Federal called drugs in car.
Drugs in car. I've seen a ganja plate, and back before marijuana was legal in most places, I think the ganja plate's an invitation to get pulled over, quite frankly. But obviously with probable cause to stop. So if you don't use your directional, you can get pulled over, is essentially what that comes down to. So again, what the state would say is that, we don't want the New Hampshire plate to have these messages that we think are offensive and we don't agree with. Well, the same thing happened here with the Sons of Confederate Veterans in Texas. They wanted to do a plate, and everything about the plate was fine except for this. Okay. I don't know if you guys knew this. The Confederacy had two flags. It had the official government. Whoops, I went the wrong way here. It had the official government flag, which is this flag, if you can see the cursor around it. but it also had the battle flag. This is the one you see on the battlefield, the stars and bars. And a lot of people associate the stars and bars with the Confederacy, and a lot of people associate the Confederacy with slavery, and then, you know, the South and the Jim Crow laws that followed, the segregation laws that followed the Civil War. And as we know, are there any states? South Carolina was the most recent state to take down its state flag or to change its state flag, which had an insert of a Confederate flag on it. And now, obviously, a lot of the Civil War monuments, there's a lot of controversy around the Civil War monuments throughout the South, because a lot of them are either Civil War politicians who were fighting to perpetuate slavery, or generals who were fighting to perpetuate slavery. So when the Sons of Confederate Veterans gave the and this is it right here. I found that on the internet. When they put in their sort of mock-up on what the plate would look like, the people in the State House in Texas saw the stars and bars on it, and essentially said, "Hey, you're good to go, except you can't have the stars and bars." And so the Sons, you know, that's the Confederate battle flag. The Sons decided to challenge it, claiming that their free speech was affected. And what this case came down to was, is the license plate expressing the state's message and within the summum holding, or was the license plate expressing the driver's message? Which would mean that the driver, there would be a content-based restriction, and strict scrutiny would have to apply. And we have all these cases that say, wait until you see some of them, all these cases that say even offensive speech is protected, okay? We're gonna see the Cohen case where a young man during the Vietnam War wore a jacket that said on the back, "Fuck the draft." And that, you know, as offensive as that is, that was protected speech. We're gonna see two cases that involve people who are charged with hate crimes for burning a cross on the lawn of Black families, okay? That was deemed to be protected speech as well. You know, it was obviously trespassing, and the kids who did it got in trouble for trespassing, but the court protected their right to burn the cross. You know, an obvious reference to the KKK and sort of the mayhem that always followed a cross burning is deemed protected speech. So the government, I mean, the court will go far to protect even the most offensive speech, as long as it's protected. But if it's government speech, then there's no First Amendment violation. So you see the argument here that sets up between the majority and the dissent. Breyer writes the majority opinion. It's a 5-4 holding, you know, cites the Summum case. Government may choose the content of its own speech. It's not unconstitutional viewpoint discrimination because the expression is the product of the democratic electoral process. The specialty license plate is an example of government speech rather than a forum that is open for private expression. And that's the part that's going to be confusing later on. We're going to talk about public forums for speech. Justice Alito wrote the dissent. Again, this was a close call. It was a 1-vote tip. He said, since there are over 350 varieties of specialty plates, anyone observing it would think that the plates were an expression of the drivers rather than of the state. So he says this is not state speech. It is a content-based, a viewpoint-based discrimination. And he would allow the stars and bars on. Okay. Vagueness and overbreadth. A lot of First Amendment cases involve vagueness and overbreadth. First, we'll talk about vagueness, then we'll talk about overbreadth. Before we do that, I want to introduce you to a new concept about how we challenge laws based on individual rights under the Constitution. We have, up until now, for the most part, been talking about so-called as-applied challenges. What an as-applied challenge is this. That law may be constitutional as to you, but it's unconstitutional as to me. It discriminates against me, but not against you. Therefore, it's unconstitutional. So as applied to me, it's unconstitutional. In as applied cases, I have to comply with the standing stuff that we've talked about, right? Constitutional standing and prudential standing, okay? It's a little bit different with facial challenges. With facial challenges, the plaintiff is asserting the law cannot be constitutional in any setting. Its very existence is unconstitutional. Now, this will be the case with a vague law. A vague law, we're going to see, gives you no notice as to how to comply with it. It is so vague, you don't know how to comport yourself to deal with it. That is therefore unconstitutional in any setting, not just against specific people. You know, it's not like some people can read and some people can't. It's just that the law is so vaguely written that no one can understand what it really means, okay? The standing requirements are relaxed greatly when it comes to facial challenges because the very existence of the law itself is unconstitutional, okay? One more point from this slide. We're on number 27. They're not mutually exclusive. You don't have to only make a facial claim in regard to a law. You can say that it is facially unconstitutional and then have as the next cause of action, as applied to me, it is unconstitutional, okay? So you can do both. Okay, so here's our definition of vagueness, at least in the context of speech. Have you guys taken criminal law yet? Did you guys talk about vagueness in criminal law? Due process and vagueness in criminal law? No, so you run into that problem in criminal law as well. So if I don't know what the law is really saying, if I don't know whether my conduct is criminal or not, how can I possibly have notice as to how I should comport myself? Teddy? No, I don't mean ignorance of the law. I mean the law is written vaguely. And so it creates ambiguity in its meaning. You don't really know what it means. And we can take this definition and apply it to criminal law as well. A law that restricts speech is unconstitutionally vague if a reasonable person cannot tell what speech is prohibited and what speech is permitted. And so it's sort of like the same thing in criminal law. I remember when I took criminal law way back, there was a case outlawing being a common scold. This is also a sexist law in addition to being a vague law. A common scold was a woman who was annoying and naggy. And so the law could, you know, the old law could literally arrest a woman who a police officer deemed to be a common scold. Now, you know, what's naggy and annoying to one person is not necessarily naggy and annoying to another, right? So how do I know if I'm being a common scold, right? If I'm expressing my opinion and you disagree with it, am I a common scold? You see the problem there, okay? That's the criminal law context. Here, the first case that we're going to have, the Coates case is going to show us how it applies in the First Amendment context as well. And again, just like with criminal law, this is as much about procedural due process as it is about the First Amendment. It's restricting my free speech rights, but it's doing so by not really giving me fair notice of what I can say and what I can't say. And so what it leads to is selective enforcement. And there's always a problem with selective enforcement. The police can't arrest everybody. So the police are going to have to decide who to arrest, right? If it's so vague, then a lot of people are going to violate the law. And how are they going to choose? Well, many times they're going to choose properly. But doesn't it lead to an increased likelihood that they may choose on the basis of bias? Or if it's one of these annoyances, they might choose on the basis that that person annoyed me. Even though he might be annoying to you, he annoyed me, so I'm going to arrest him. So selective enforcement is sort of antithetical to our notions of democracy, and that's, why we will strike down laws that are void for vagueness. There's a problem, however, with applying the vagueness doctrine. If you do it too precisely, if you're too willing to do it, then a lot of laws are going to get shut down. Okay. Ambiguity is inherent in all language. None of us write perfectly clearly. Have you ever talked to someone with a particular meaning in your mind and they construe it entirely differently than you are construing the words coming out of your mouth? Well, the same thing happens with the written word. Now, add to it the fact that these laws are written by legislatures. And if anyone has ever tried to write a document in a committee before, you know that the document is never exactly the way you want it, and that everyone is going to get their 2 cents into it. And you might get a document that's a little bit more muddled at the end. Well, that's what happens with legislation. Obviously, it's the product of compromise. So we just can't say, well, that's a little bit vague, so we'll shoot it down. So what we're going to see later on is we have to have material or substantial vagueness, not just minor vagueness. So here's the Coates versus Cincinnati case, 1971. Cincinnati ordinance makes it an offense for 3 or more people to assemble and engage in conduct, quote, annoying to persons passing by. So if you're playing a song on your iPhone that I find annoying and you're with 2 other people, right, you can get arrested. Or can you? I don't know. Supreme Court strikes this down. It's an unascertainable standard. What's annoying to one person is not necessarily annoying to another. The ordinance does not provide a comprehensible normative standard. And that's a pretty easy case, isn't it? 3 or more people to annoy persons passing by. That's a pretty easy situation. Baggett versus Bullitt, 1964. To work for the state, you had to take a loyalty oath that said you promised you were not a subversive person. You had to swear that you were not affiliated with any subversive organizations. Well, we're in a presidential race. I think we could agree that the 2 presidential candidates disagree on what subversive is. Wouldn't you agree with that? And so what does subversive mean here? The law is too vague, ambiguous word, provides little guidance as to what speech and associational activities are proscribed. The doctrine of overbreadth is a bit more complex. If the law that's meant to prohibit unprotected speech also prohibits protected speech, it is overbroad, okay? So it's overbroad if it's substantially, and that word substantially is important, if it substantially regulates more speech than the Constitution allows it to. A person subjected to the law must be able to demonstrate that it can also be applied to others who are engaging in the constitutional activity. The analogy I give to show you overbreadth is the damn filtering software we have at this law school. Have you guys ever gone on the internet in here and put in a words, Google something and gotten, it's happened less more recently, when we first put in the filtering software, it used to happen all the time. So you put in, well, I'll give you an example. If I wanted to play solitaire on my computer and get an app that would put solitaire up, I would go to, you know, Google Play or the Apple Store, and I would put in, you know, solitaire, and then, you know, a website would come up for me to download it, and but it wouldn't, because the MSL filtering software would put up a little notice that said, this site is banned. It's about gaming. You know, in other words, gambling. And they want it to ban gambling. Or it used to be that if you put anything in relating to beer and wine, if you tried to Google anything relating to beer and wine, you'd get blocked. Now, what the school has done is the way that filtering, so that filtering software is overbroad. You know, obviously they don't want their professors and students looking at porn while they're sitting in the school, okay? And so that's pretty valid. That's pretty valid. And I'm going to plead the fifth on whether there was a reason for them not wanting that or not. I'm joking. So you know, that's a valid thing to want to filter, but at the same time, you know, it's based on keywords, and the keywords can be construed in different ways, and it's going to be overbroad in its application. It's going to prevent you from getting into legitimate uses and the like. Okay, so you know what I used to like to do? I like to do the crossword puzzle. I do the crossword puzzle every day. These days, no one gets a real newspaper, right? So I do the crossword puzzle online. When I was first here at the school, I would get blocked because the crossword puzzle was gaming, essentially. So that's an example of over breadth. Okay. Here's the ultimate overbroad law: Shad versus the Borough of Mount Ephraim. So in Mount Ephraim, there's this adult bookstore that has this really cool new idea. Peep shows are coin operated shows where you look into a viewing area, you put in a coin, you know, like a quarter or something, and then you would get to see, you know, I don't know, 5 minutes of kind of soft pornography type stuff, nude dancing or something like that. You have the right to remain silent, Teddy. So I'm gonna. I would recommend that you exercise that right right now. So this adult bookstore decides to take this one step further. You put in your quarter and you look into the viewing screen, and you don't see a motion picture. You see live dancers who are naked, who are dancing. So the borough didn't like this, and it enacts an ordinance. And talk about overreaction. What does the ordinance prohibit? All live entertainment. Okay. I mean, are you guys thinking of examples of how this is overbroad? If you go to church, do they play music at church? Is music entertainment? So they're going to be shutting down, you know, choirs in churches, or organs in churches and things like that, and school dances. That's live entertainment. Plays, concerts, musicals, dances, even political or ideological speech might be deemed live entertainment and shut down. So the court here said this is severely overbroad. Some overbreadth is not enough. For the law to be stricken as overbroad, it must be substantially overbroad, okay? It must restrict substantially more speech, and you've got to be able to show that it's going to not just be this one case where it's going to happen, it's going to happen in other cases. And so you get these kind of inconsistent results, okay? A facial claim must demonstrate a significant number of situations in which the claimed overbroad law could be applied to constitutionally protected activities. So these cases, there's no substantial overbreadth. The Ferber case is a child pornography case. We'll talk about that in more detail later on. There are overbreadth, but these are pretty obvious cases. Houston versus Hill. It's unlawful to interrupt police officers in the performance of their duties. So in other words, if a police officer is sitting on the side of the road with a radar gun and you walk up to him and say, "Excuse me, officer, that house is on fire over there," you have interrupted a police officer who's in the performance of his duties, and he could arrest you for doing that. So obviously goes way further, gives discretion to the police officer to arrest people who might be engaging in protected First Amendment activity. And this one is truly amazing to me. Board of Airport Commissioners versus Jews for Jesus, Inc. Jews for Jesus used to be a big proselytizing organization. They used to be everywhere. They would proselytize at homes, but they were often in malls and in airports and places like that. A lot of people find proselytization annoying. You don't like it when a Moonie comes up to you and tries to sell you a flower and tell you about the Moonie doctrine, right? You would rather just do something else. So LAX, the airport in Los Angeles, a public airport, has a resolution that bans, quote, all First Amendment activities within the airport. So think about what that means. All free speech is banned. I can't open my mouth, right? I can't look at a newspaper because I'm engaging in virtually everything you do in an airport is somehow related to First Amendment activity. And this is like the ultimate overbreadth. Again, how do the police choose who to arrest and who not to arrest? And it gives far too much discretion, okay? All right, this is based off of a real case that occurred a number of years ago in the district court for the District of Massachusetts. I have a multiple choice question for you. Many officials and residents of the city of Lowell, Massachusetts have come to believe that panhandling has become too common and that panhandlers have become too aggressive. And you guys know what panhandling is, right? It's begging for change, essentially. In response, the city has passed an ordinance that defines panhandling as, quote, the solicitation of any item of value through a request for an immediate donation. And it makes it a criminal offense to panhandle in an aggressive manner. In the year since the ordinance has been adopted, municipal police have arrested 3 panhandlers under an assertion of authority created by the ordinance. A youth sports organization that desires to solicit donations in front of a Market Basket supermarket has challenged the ordinance on the ground that it violates their First Amendment free speech and free expression rights. I mean, you could see that. Have you guys ever seen Girl Scouts selling Girl Scout cookies in front of a supermarket? Well, some of those girls can get very aggressive in their sales techniques, can't they? You were pretty aggressive? Yeah. Yeah, exactly.
Yeah.
And so you see where I'm going. You see where I'm going with this is that, what is an aggressive manner? What does that mean exactly? And does that mean physically aggressive, or does that mean, verbally aggressive, or does that just mean using hard sales tactics type thing? So the most likely ground a court will employ in striking the statute is A, there are no provable secondary effects from panhandling. You don't really get into secondary effects unless the government raises the issue. But doesn't look like a good answer, but we're not gonna rule it out yet. B, vital parts of the ordinance can be applied in an overbroad fashion. That's looking pretty good to me. Is it looking good to you? Okay, it's gonna get that Girl Scout landed in jail. C, the ordinance violates the panhandler's rights under the Equal Protection Clause of the 14th Amendment. First of all, we haven't done the Equal Protection Clause yet, so that wouldn't be a right answer. Second of all, if you think about the scrutinies that we did, the enhanced scrutinies are, the cases that the plaintiff actually wins. Race, national origin, alienage, gender, and fundamental rights. Is the right to sell cookies on a street corner falling within one of those enhanced scrutinies? No, it's going to be a rational basis. I'm sorry. And so they're probably going to lose. D, the ordinance constitutes a taking of panhandlers' property in violation of the Fifth Amendment of the Constitution. That's a little silly because prospective property is not property, is it? That would have been my property that you're taking away from me by not allowing me to be aggressive. Our only possible choices are A and B is the much better answer than A. There's nothing that shrieks of secondary effects here. I guess in the real case, by the way, some of these panhandlers in Lowell, they would walk up to you at a stoplight and they would ask for money. And if you didn't give it to them, they'd get in the passenger side of the car. And they basically sit in your passenger seat until you gave them some money, and then they'd say, okay, I'll leave now. And it seems to me that the city could have come up with a less restrictive way of dealing with that, right? The squeegee guys in New York, and they try to guilt you into giving them the money, and Mayor Giuliani banned that, right? Made that an offense. Okay, all right. This is a big topic that we're probably not going to get through today. Prior restraints. Let's look at the history of this a little bit before we get into it and see why this is such a big deal. Unfortunately, there are different types of prior restraints, and it does tend to be tested on the bar exam, so it's worth spending some time on. Remember, the framers did not write the Constitution in a vacuum. They didn't just sit around and say, hey, what do you think would be a good form of government? They used their experiences of the American Revolution in determining how to make, the type of country that we have now. And one of the things that really bothered them was what we now call a prior restraint on speech. England would require government approval of speech prior to, posting it. So back then, one of the most common ways to post news was to create a broadside, write on a piece of parchment and then come and tack it up to a big board that would be, say, on the Boston Common type thing. Well, that became against the law. You'd have to show it to the colonial governor's office, and they would have to approve it before you could put it up. That is what we call censorship. This is the big thing that we're trying to avoid when we ban prior restraints, is no censorship, okay? Then the other thing that would happen is there'd be stamp taxes. If I wanted to publish a newspaper or publish any type of a broadside, I would have to show it to the government, and they would then make me pay a fee to be able to publish it, a tax to be able to publish it. And so, if I don't have the money to pay the tax, I'm not likely to publish it. And again, so through charging money, it's a form of censorship, okay? And the result of this is that the Supreme Court has historically been very vigilant in preventing prior restraints. And I suggest perhaps, being a little bit too willing to prevent prior restraints as well, okay? So the whole thing is censorship. Obviously, if I'm about to say something and the government can run into court and get an injunction to prevent me from saying it, they have effectively censored me. Why have they effectively censored me? You guys took civil procedure. Did Dean Coyne obviously talked about injunctions, Rule 65, right? And the criteria necessary for injunctions. Did he talk to you about the court's remedy for breach of an injunction? Did you learn about contempt at all? So you talked about contempt. If you breach an injunction, you're breaching a court order to preserve the sanctity of the court. The court can hold you in contempt. Holding you in contempt can often mean imprisoning you, putting you into the cooler. This creates the collateral bar rule that flowed out of this idea. So let's say that a trial court wrongfully enjoins you from being able to speak, okay? This is the Walker versus City of Birmingham case. Martin Luther King, many times in the South, the cities or towns would come in and get injunctions to prevent the civil rights advocates from marching or from holding rallies and the like. Clearly violations, obvious violations of their First Amendment rights. So the problem here is that, you know, MLK would take the jail time to be able to speak and often ended up in jail. Sort of the price that he paid, and, you know, his associates as well. The problem is that even if the injunction was wrongfully issued and was later overturned as being wrongfully issued, that was not a defense to a contempt charge. The courts were more interested, the collateral bar rule essentially says that the sanctity of the court order is almighty. And even if it is wrongly issued, the court can hold you in contempt. So this has a big chilling effect on speech if you use the courts to try to censor speech. So because of this, the Supreme Court has consistently ruled that prior restraints are the worst form of governmental regulation of speech. They are often unabashed censorship, and they should not be allowed except in the most extreme circumstances. So we'll see a couple of cases where we have some easy calls, and then we'll see a couple of cases where we don't quite have some easy calls. The first is Neer versus the state of Minnesota. Minnesota had a law that said any malicious, scandalous, or defamatory newspaper, magazine, or other periodical is a public nuisance. And any person producing, publishing, circulating, selling, having in possession, or giving away such matter will be subject to an injunction and a fine. So there's a kind of a hysterical, bigoted publication called the Saturday Press, and it ran a series of articles suggesting that a certain Jewish gangster who controlled gambling, bootlegging, and racketeering in the city of Minneapolis was able to do so because law enforcement officials, wink, wink, nod, nod, were not doing anything about it. In other words, he was suggesting that that not just any gangster, a Jewish gangster, obviously, you know, a bigot who was publishing this, is paying off the cops to let him do what he is doing. So, using this law, the county attorney, the equivalent of the district attorney, goes in and gets an injunction. The state court enters a permanent injunction that essentially shut down the Saturday Press, put the guy out of business. Okay. Supreme Court called this censorship. It's clearly a prior restraint. So in other words, before the speech happens, right? So think about this. You're prevented from saying it before it happens. MLK would have said what he was going to say, knowing he was going to be thrown in jail or beat up. Okay. he was still willing to say it. There was no censorship there because he was usually punished after the fact, not before the fact. But if you get prevented from saying it before the fact, no one is going to hear your speech, right? That's the whole essence of why a prior restraint is wrong, okay? However, a couple of interesting cases here. Has anyone seen the film that came out 2 or 3 years ago with Tom Hanks called The Post? The Post was about the Pentagon
have.
Papers case, the New York Times versus United States. I happen to be old enough to remember when this happened. I remember Daniel Ellsberg being on the news. I remember this whole thing. So I'll give you a little background behind this. Daniel Ellsberg was an officer in the United States Army during Vietnam. He was a highly educated guy. He was very pro-Vietnam, was sent to Vietnam, saw action in Vietnam. And as he was there, he essentially grew to be against the war. He thought that the United States wasn't being truthful with the citizens on the way that the war had been run. So when he came back, he was discharged from the military, honorably discharged from the military. He became an anti-war advocate. He worked for the RAND Corporation, which is a think tank that does consulting work for various agencies. The RAND Corporation did a lot of research for the United States government and was paid for the United States government. And what he discovered was that the Secretary of Defense, Robert McNamara, had commissioned a history of the Vietnam War, essentially from the very beginning to the end. Tried to determine why these decisions were made, in essence, to educate the Pentagon as to how to avoid the types of mistakes that had happened. And it was a very extensive work. And the RAND Corporation was hired to do part of this job. And Daniel Ellsberg discovered this document, the so-called Pentagon Papers. And what he did was he rented a hotel room, and every single night for a number of weeks, he would put a few pages from the Pentagon Papers, thousands of pages, put a few pages in his briefcase, take them home, go to the hotel room where he had set up he actually rented a Xerox machine, and one by one made copies of the pages and then returned them, then brought another few home and eventually had all the Pentagon Papers. He then contacted both the New York Times and the Washington Post and agreed to give these to the news organizations for them to publish. The government found out what was going to happen right away, ran into court, and it got an injunction against the New York Times from publishing them. The injunction was against the New York Times, but not against the Washington Post. Guess who ended up publishing the early parts of the Pentagon Papers? The Washington Post. Government went in and tried to get an injunction against the Washington Post. The case quickly escalated and wound up at the United States Supreme Court. The United States Supreme Court deemed this to be a prior restraint and refused to keep the injunction against the New York Times and Washington Post and allowed the Pentagon Papers to be released. Court said any system of prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity. The government failed to meet its burden of overcoming the presumption, and the publication will not be restrained, okay? Now, as it turns out, there was not any real classified information in the Pentagon Papers. I'm not sure this was known at the time, but the court still went and applied the prior restraint rule and allowed this information to be released. The Black and Douglas concurrences, remember, they were big judicial advocates. They saw this as pure censorship. Look at Black. The injunctions are flagrant, indefensible, and a continuing violation of the First Amendment. Both the history and language of the First Amendment support the view that the press must be left free to publish news, whatever the source, without censorship, injunctions, or prior restraints. Hugo Black was a big First Amendment hawk. He came as close to being an absolutist with First Amendment as anyone. He even dissented in the obscenity cases, saying he thought obscenity should be protected speech as well. And not far behind him was William O. Douglas as well. The dissenters said, why are we doing this so fast? Not such a simple case. The government should be given more time to look through the materials, see if there's anything there that should be redacted, essentially, and leave the injunction intact until that, in fact, happens. But that was the dissent, only 3 of them there. Now comes the case that was never resolved of the United States versus Progressive Inc. Progressive is obviously by the name of Progressive magazine that had almost a radical point of view, a far left point of view, perhaps even a radical point of view. And they had an article that they were going to publish, and the article was going to explain how to build a hydrogen bomb. So, the question became, the United States sued to try to prevent the article from being published, obviously saying that this involves national security interests. And before the court could decide on whether to issue an injunction or not, guess what happened? The case became moot. Do you know why the case became moot? Article got published by another source. And so it was already out there. Now, come to find out that there's nothing really, dangerous about people knowing how to build a hydrogen bomb. Good engineers can now easily build a hydrogen bomb if they have the proper materials. What's the hard part of building a hydrogen bomb? Yeah, getting your hands on the nuclear materials to be able to do it. That's what largely had prevented Iran from being able to develop nuclear bombs. Okay, and that's sort of the tack that we take now, is to make sure that we know where the materials are that could be used in these bombs, and try to control that part of it. When the USSR fell and became Russia, you know what the biggest concern was? As all these breakaway states were declaring independence from the Soviet Union, the biggest concern that the United States had was that we were losing control over the nuclear materials, the missile silos and the like, because we had treaties with Russia that kind of safeguarded all this stuff. The SALT treaties, the strategic arms limitation treaties. Unfortunately, once these breakaway states came into being, we didn't have as much control. So there was a big rush to try to get that control back. We have one case involving prior restraints and fair trials, so to speak. Nebraska Press Association versus Stewart. Gag orders in trials, never easily implemented by courts because of the prior restraint rule. So here there's a multiple murder that had attracted widespread news. The defendant was about to go on trial. There were journalists in from the entire country, broadcasters, national wire services. Apparently the defendant had made some confessions, or at least what was alleged to be confessions. The court was very worried that the guy would not get a fair trial. So it put a gag order on, a restraining order, preventing the news organizations from publishing the details of these accounts of confessions or admissions made by the accused to law enforcement officers or third parties. Okay. The newspapers challenged this, and the Supreme Court said, you shouldn't have done a gag order. This is a prior restraint. You should have instead looked for alternative ways of dealing with this. So do you remember what, you guys don't remember because you probably were not born yet, with the O.J. Simpson case? They moved the case out of Los Angeles County to Simi County because of all the publicity that it had garnered in Los Angeles County. So that's one way of doing it. Another way of doing it is sequestering the jurors so that they're not going to hear all this news information. Another way of doing it is making sure that when you are examining the jurors, that you ask them a lot of questions about what they've heard, what they know, and that type of thing. A lot of times they say in high publicity criminal trials, the best jurors are the ones who are the dumbest, the ones who don't read, the ones who don't form, prejudgments based on what they've already read in the media. So there are other things that could have been done. This should have been a last resort. Putting a gag order is a prior restraint, and it should be a last resort. All right. Now, this is actually probably a pretty good place to stop. I had been hoping to get a little bit farther than this, but that's okay. Licensing as a prior restraint. This is the most common form of prior restraints that we all deal with every single day, okay? What we're doing here is, where the friction is going to be is with the police power that the state and local governments have to protect health, safety, and welfare up against the individual right of free speech, okay? So for example, just let me pose the following. Two groups want to have a rally on the town common at the exact same time and the exact same day. One of the groups opposes abortion. The other group supports a woman's right to choose to have an abortion. If you let those two groups show up at the same place at the same time, what's going to happen? Trouble, potential violence, okay? Does the government have a police power right to worry about the health, safety, and welfare of the participants, as well as those who accidentally end up in the area at the same time? Of course. But whichever side you're on the abortion issue, do both sides have the right to express their opinion in that regard? Yes, they do. And generally on public land, yes, they do. Okay? So you see the conflict that's setting up here. But at the same time, if you say you have to get a license to do it, isn't that a form of censorship? Now all of a sudden you can control the speech, right? So this is the issue that we're going to deal with when we start with this on Tuesday of next week. Okay? All right, guys, you have a safe weekend.
You too. Thank you.
Hare Krishna, yep. Hare Krishnas, Moonies.